let's just put it on me for now.
So we'll keep moving on until you tell us, or you want to wait till we get.
Wait a few more minutes.
Fine.
All right. Yeah, just tell Mr. Young we're waiting.
When we reach the 20, I'll let you know.
Well, or 9 o'clock.
Well, that's.
George, you can. Well, no, you gotta operate that. Judge, can I grab one more chair from here?
I'm sorry?
Oh, no, we need this.
Yeah.
Okay.
Ask the guys where they can get you a folding chair or something.
All right.
They'll hook something up.
One works for you guys?
Yeah, we just need one. Thank you.
You're welcome. Conversation here. You want to mute? That's mute.
Thank you.
Hey, Bob, because you're gonna be in here most of the day, your office is closed but not locked.
Yeah.
It's a personal property.
Yeah, that's fine. Hang on.
I'll let you know.
All right.
You can come and go as you please.
All right. We just reference this one.
computer guy said when it's time to play.
We'll see what George knows.
It's time to play.
And you can operate from that.
Yeah.
Okay.
Sure. It's like an HDMI from.
Right. Then it, it's kind of- You put away my stuff. Yeah. You got your phone? Text you.
Yeah.
Craziness going on. It's crazy. Really?
It's a lot of regulars.
Video retention. That's it.
Geez, I don't know. Somebody. It just says it's lives. Yeah, it shows one next to the camera, like one person's view. But then again,
Good.
that'd be funny if you did. Cheat like that.
The Jews. So, yeah. Yeah, at least. Let me start. Yeah. no, it's good. Time.
bad.
Yeah, let's see how Joe did today. Are we ready to bring him in, fellas?
Gunner, is court conduct the majority of the voir dire, or will there be an opportunity for questions, or what is?
Yeah, you'll get a chance. You'll get a chance.
All right.
Oh, yeah. Oscar Crowe.
Yes, please.
Number 9. Number 14. 23. And 25.
You want to have it? I know he's got it.
Thank you.
So right now, I'm looking at nothing. I've got like a big red screen. That's what you want.
Recording in progress.
Hey, Joe. Okay. All right. Good morning, folks. Wow.
Morning, Judge.
Wow. It's Monday. Okay. So, folks, well, you know who I am. I've got the nameplate. My name is Brian Oakland, one of the judges here at the court. So my primary function today is to make sure that whoever ultimately is picked as our jury has the information they need to make the decision we're going to ask you to make. So I tell you that to tell you this. There are a number of jury instructions that I am required to give you. That's part of the information you're going to have. We've got, in Michigan, we've got 3 volumes of the criminal jury instructions. You guys don't get them all, don't panic. But to do that, because I'm not good enough to have them memorized, and we don't have enough money to have a teleprompter like the politicians, so I can read while I look like I'm talking to you. I'm actually going to read to give you that information, and I'm going to start that pretty soon. So I tell you that because I'd much rather engage with folks and make eye contact, even though my contacts aren't working today, and most of you don't really have eyes from here. I see faces. But I'm going to read, and you're going to look at my forehead for a fair amount of the time this morning, unfortunately. So I'm going to get that started right now. I told you who I am, and we represent 5 communities here at the 34th District Court: Belleville, Romulus, Sumter, Van Buren, and Huron. Any of you folks don't live in one of those 5 communities? Great, okay. One of the things that those of us that work in the system, the attorneys, the staff, myself, one of the things we recognize is that jury duty for most people is not something that you look forward to. I know it's shocking, isn't it? And one of the reasons I think that is because we're asking you to come to a place that you're not comfortable being. Let's face it, most people don't go to court because it's a warm, fuzzy feeling. It's usually something bad, whether not really bad or just slightly inconvenient has happened. We're asking you to come to a court that you don't normally want to go to. We're asking you to come here to do a job that you have not been trained to do. And we're asking you to do it with people that probably are strangers to you as of right now. So that doesn't make for a warm, fuzzy feeling. And we understand that. So our job is to try to make things easy for you. With that in mind, if there's anything you're uncomfortable about, it's too hot in the room, it's too cold in the room, when you get into the room where we actually give you some coffee, if the coffee's cold, whatever it is, just let the staff know. If it's not something they can take care of, they'll let me know and we'll make something up. We're going to try to make you comfortable today. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us to choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called the voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. Are you all hearing me okay? Yes. Anybody have a problem with me? All right, I'm fairly loud. So if at any point you don't hear what somebody's saying on my side of the bar that separates that little half wall, everything that's set up in front of that bar, you should be able to hear. So if it comes out of a witness's mouth, it comes out of one of the attorney's mouths, you should be able to hear it. If you can't, just, grade school, just get our attention, let us know what's going on. During jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you're excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this case. I will now ask you all to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. If they jumped right to their feet, if you would, folks. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Yes. Thank you very much. Have a seat. All right, I've already told you who I am. This is Heather Mortsfield. Heather is my secretary recorder. Her job out here today is to make sure that what is said on my side of the bar is accurately recorded in case she has to provide a transcript down the road. That's important information for you prospective jurors to understand for two reasons. Number one, we don't like those kind of answers because Heather can't record them. Even though the people in the room might be seeing the head shake or the head nod and know what the answer to the question is, she can't record it. So try to stick with the yeses, the nos, and by the way, I don't know is a perfectly acceptable answer to a question. The other reason it's important for you to understand her role is if two voices are being recorded at the same time, you can imagine how bad that is. And all of these microphones around the room go right into the recording equipment. So if an attorney is asking you a question during voir dire, for example, and you start your answer while the attorney's still speaking, that's a garbled mess, makes her job really, really difficult. And she's okay the first couple times, and then she starts to shoot me dirty looks, and then I got to do something about it if I want any peace. So just keep that in mind. Maybe wait for that extra pause if somebody's asking you a question. Make sure that's done before you start answering. So this is a criminal case, and it involves a charge against, a charge of interference with police, which I'm going to explain more fully later. These charges have been made against the defendant, Travis Blake Walton St. Clair, who I'm probably going to refer to the rest of the day as Mr. St. Clair. His attorney is Mr. Samir Jadala. Would you please stand up and introduce yourself? Any prospective witnesses?
Hello, everyone. I'm Attorney Samuel Vidal. I represent Mr. Singh. The judge will further into that. You don't need this with the defense.
Thank you, Mr. Jadala. And Sumter Township is the municipality bringing the charges against Mr. St. Clair. Township is represented by Attorney Robert Young. Mr. Young, if you please stand and do the same with witnesses.
Yeah, thank you, Your Honor. Robert Young is my name, Suffolk Township Attorney, and for purposes today, the prosecuting attorney. For certain, as far as witnesses are concerned, Detective Lieutenant Joseph Pulowski, who's sitting next to me, will testify. And is it all right to name a couple of others that may be?
Sure,
Probably
absolutely.
depends on how circumstances
Sure.
should arise, but Sergeant Beth Eager, Officer Gino Crescini, Officer Nicholas Johnson, and possibly Chief Eric Luke may testify, depending on how circumstances go.
Thank you very much.
Thank you, Your Honor.
All right. So we've got Officer Crova and Officer Garcia in the courtroom. The court officer's main job is to make sure everybody in the court is safe. I don't think that's an issue today. So their secondary function is to just be a conduit between you folks and me. Once again, coffee's not hot, room's too cold, whatever it is, whatever you need, let us know. Do any of you folks know anyone that's been identified, either that is in court or maybe just a name that one of the attorneys mentioned?
No.
Anyone? Wonderful. All right, how about health issues? We've already established that you guys can all hear me. Anybody have any health issues, maybe back problems that prevent you? You notice I don't sit. I've had back problems forever, and I finally realized that if I stand all day, it actually helps. Any of you have problems sitting for, a couple hours at a time? Anyone? Sir, in the back row. Sir, what's your name, first of all?
Frank Sedler.
Sedler? And what's the issue, Mr. Sedler?
I got sciatic nerve.
Oh, boy, bless you. Which I'm assuming, because I have friends with that issue, that you just can't park for long. You got to get up, you got to move around a little bit once in a while.
Some days kind of come and go. Some days it doesn't bother me too bad. Other days it's one of those things where I gotta get moving around.
Yeah. Okay. Great. Perfect. I mean, not good for you. Don't get it. But if you need to get up and move around, just once again, can we have a break? Okay. And sir, in the front row, what's your name?
Robert Doty.
Dodick?
Doty.
Doty.
Yeah, I've had a back problem for a long time, and sometimes is it okay just to stand up?
Absolutely.
Okay.
Absolutely.
So that relieves it.
Yeah, I know. Okay, sure, absolutely. Anyone else, any kind of health issue that would cause you either a lot of discomfort or, something that would, anything that would, not just health. Does anybody have any reason why they can't be with us today for a business day? And what I mean by that is into the afternoon hours. Health reasons or any other reasons? No? Okay, wonderful. All right, as I said, this is a criminal case. The document used to charge Mr. St. Clair with a crime is called a complaint. The complaint in this case charges that Travis St. Okay, it's Monday. The complaint in this case charges Mr. St. Clair with the crime of interference with police and reads as follows. The complaining witness has filed a sworn complaint stating that on the date of January 6, 2023, and at the location described, the defendant, contrary to law, and it's not there. Oh, okay. Skips down. Did interfere in the lawful arrest of Paul DuPont on multiple outstanding warrants, then interfered into the subsequent narcotics investigation. The ordinance of the township reads, it shall be unlawful for any person to resist lawful arrest or interfere either directly or indirectly with an officer making an arrest, or to refuse to assist an officer upon being commanded by the officer to give assistance, or to refuse to disperse upon the command of an officer, or to object, resist, hinder, or oppose any officer in the discharge or apparent discharge of his duties. All right, attorneys, in the instructions, Heather's got the full complaint. I don't know if it's necessary for the purposes we've got right now to read the whole thing.
Your Honor, may I?
Yeah,
The jury instructions that have been submitted, approved by Mr. Jadala and myself, and I assume would not be an objection from the court, is limited to the Sumter Township Ordinance 14-27, which was the second portion of the complaint you read. So it's just that ordinance that we're focused on.
okay.
As far as the state statute is concerned, we're not.
That's not my
focused on it.
question. My question is what she's got under reading of complaint. Do you want the entire body that she's got typed in the instructions read? That's the question.
No,
No,
You're satisfied with what I've got so far?
satisfied, Your Honor.
All right. Moving on. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Mr. St. Clair is innocent. The presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just a doubt, just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances. All right, so Officer Krove is going to call names. First of all, when he calls your name, if he mispronounces your last name, please correct him, because if he doesn't, we're going to assume that that is correct pronunciation. The attorneys and I will make note and we'll mispronounce your name for the rest of the proceedings. So correct him if he misspeaks. Second thing is, as you approach, right next to me, there is an incline ramp. It's not real visible, so you got to be careful, otherwise you'll trip as you come up the incline ramp. When you get in the jury box, Joe will show you where we're going to be seated. Juror number one is going to be seated closest to the prosecutor's table, and then we'll fill in from there. If you will, Joe.
Juror number one, Jeffrey Adwell.
Thank you, sir. Watch your step. No, sir. That's okay.
Oh, sure. I'm sorry, if any of you has a cell phone, so it lets you know now what's to be completely silenced or shut off. We don't want any noises at all or interruptions. Sorry. Juror number 13, David Kurtzall. Kurtzall. Who's Kurtzall? You're juror number 2.
Welcome, sir.
Juror number 3, Juliet Weigel.
Say it again for me.
Legal.
Weigel. Thank you.
Juror number 4, Todd Wardinger.
Wardinger?
Yeah.
Wardinger. Thank you, sir.
Juror number 5, Letitia Johnson. Lashida Johnson. Ashida Johnson, I'm sorry. Number 4.
Watch your step right here.
Next juror, Melanie Morgan. And juror number 7,
Good one.
Tiffany Brown.
Welcome, Ms. Brown. Very subdued crowd. Usually at this point, some of the folks back there have huge grins on their face. All right, you folks are not out of the hot water yet. So what I'm going to ask you to do, as the attorneys and I ask questions of these 7 folks, I want you to answer those questions to yourself in your head. Because if one of you finds yourself in a seat up here, the first thing I'm going to say is, were you listening to the questions that had been asked? Is there anything we should know based on the questions, so on and so forth? It just helps us move things along a little bit so we don't have to repeat the same questions over and over, hopefully. All right, so with that, we've already established that you all belong in this courtroom because you're a resident of one of my 5 communities. No health issues, right? Yes,
I
sir.
live in Brownstown.
You live in Brownstown, or your zip code is in Brownstown?
I live in Brownstown, but my zip code is, my mailing address is Romulus.
Okay. Huh.
I live on Sibley Road, so we don't, Brownstown doesn't have a post office, so you can either go Romulus or Riverview.
Sibley where?
Between Beach Daily and Anchor.
Hmm.
Pearsall Farms.
Yeah, yeah. Sounds like Brownstown. Yeah, okay. Get out of here.
Handle up.
You should probably be doing some farm stuff today anyhow, shouldn't you?
I get back to the greenhouse.
Yeah. Enjoy your day. I don't know how that happened.
That's my mailing address, probably.
Yeah, that's probably why. That's fine. All right, well, replace Mr. Kurtzel, Officer Grover.
Juror number 2 will be Robert Doherty.
Tony,
Doherty.
Watch your step. Empty seat over here. Yep. That helps us keep track of everything. Yep. Okay. So you folks, any of you folks have any close relationships with law enforcement officers, maybe family or friends? Anyone? Okay. Any of you folks ever served on a jury before? No. Ever gotten to this point in a jury trial? All right. Yes, sir. Mr. Adwell, where at? Was it local or downtown?
Downtown.
Okay. Did you get to the point where you were asked questions?
Yes, sir.
Okay, but you were not chosen.
Actually, they did choose us, but the next morning they had a plea deal, so.
Okay. Okay. You were all ready to work. They just didn't work you.
Yes.
Okay. Okay. Criminal case? Just out of curiosity?
Yes.
Okay. All right. How long ago was that?
2 years ago.
Okay. Okay. Nobody else? Okay. All right. Anything about that process that, left a bad taste in your mouth, other than the fact that it wasted a little of your time?
Well, I mean, I'm a business owner.
Yeah.
It motivated me to pay people to do jury duty.
Yeah.
That's how many people were bailing out. They
Right.
said they weren't getting paid.
Yeah, but you got paid really well for that day. Probably lost money. Did you buy lunch while you were down there?
Of course.
Yeah. So between parking and lunch, you probably lost money. Yeah.
But it's every,
Yeah. Well, it is. And the good news about being here is the parking's free.
that's great.
Yeah, yeah, okay. Just out of curiosity, anybody else ever been on a jury? Ma'am, what's your name? Where at?
In Detroit,
36th District Court or Circuit Court?
36 district.
Okay, okay. Yes, ma'am, name? Where at? Oh, you're an experienced juror. Okay, all right. So you were all the ones that were excited about getting a notice for today, because you've done it and had fun. Right, okay. All right, back to work. Have any of you folks ever been involved in a criminal case? Maybe a witness, maybe a defendant, maybe a victim? Any ever been involved in a criminal case? All right, Ms. Johnson, let's start with you in the back row. How are you involved? Okay, how ancient history is that? If 19? All right, so not too long ago. Okay, all right. And Ms. Morgan?
I was a witness in Toledo for a road rage incident.
Okay. Circa when? Long time?
Yeah.
Okay, okay. Yeah, Mr. Warding.
I was a witness also in a, I guess, insurance fraud case
Okay.
many years ago.
Long time. All right. Was there another hand? Yes, sir.
As a defendant,
Okay. How far back?
75.
That's ancient history. Right. All right. Anything about your experiences, either as a defendant or a witness, that would cause you to be less than objective to both sides today? You'll be fair to the prosecution. You'll be fair to the defense.
Yes.
Nothing. Okay. All right. All right, folks. I call them TV phrases. You know, if you watch any of the court or cop shows on TV, you hear these phrases all the time. Presumed innocent, right? You didn't hear that phrase from me for the first time today, did you? Okay. And presumed innocent, although it's a weighty concept, I think it's pretty simple. For example, Mr. St. Clair has been charged with a crime. If I said, hey, guys, how about we just short circuit this right now? I'm going to have Joe take you back in the deliberation room. Come on back and tell me what you think. Is he guilty or is he not guilty? Should be a pretty quick decision, wouldn't it? Why? You haven't heard anything. Well, you've heard a lot from me, but you haven't heard anything about testimony or the stuff you need, right? He's innocent right now. He's presumed to be innocent. That's it. It's a weighty concept, but it's pretty simple. You all agree with my assessment and my definition of that? No problems with that? Okay. Beyond a reasonable doubt. Mr. Young's burden, and I use that word intentionally because it is a burden. His burden today is to prove to you each and every element of the crime, and you're going to hear those elements more than once before I'm asking you to make decisions. Each and every element of the crime, he has to prove to you beyond a reasonable doubt that it in fact is true. Now, reasonable doubt, what does that mean? So I'm looking at you and I'm going to guess that all of you folks are of an age where you've made some pretty important life decisions. Anybody make a decision to buy or sell a house? And have you ever done that? Pretty big investment, pretty big decision. How about just buy a car? I mean, that can be a pretty big investment, right? Any of you choose to spouse up or despouse? Anybody make a marriage decision or a divorce decision? Huge decision, right? Okay. How do we make, as individuals, how do we make those important decisions in our life? We gather the information, right? We apply our reason and our common sense, and we make a decision. Would you agree with me? That's the process that we make, you know, maybe not for lunch, you know, what are you gonna have today, but for an important decision, that's the process we follow, is it not? If we're a reasonable, you know, intelligent human being, okay? That's what we want you to do today. Now, the good thing is you don't have to gather the information. The information is going to come to you. You don't have to go look for it. I'm going to give you jury instructions. The witnesses are going to give you some facts. All right. You're going to apply the information that we provide to you. You're going to apply that, what you're going to apply to that information, your reason and common sense. And then you're going to answer that question of, has every element been proven to you beyond a reasonable doubt? Your reason and your common sense. If, when you apply your reason and common sense, you still have doubts, then by definition, that has to be a reasonable doubt. Follow? All Everybody comfortable with my definition? Okay, and you're comfortable holding Mr. Young to that burden? All right, and I mentioned it earlier. Mr. St. Clair and Mr. Udala can sit right, they can play hangman all morning. They don't have to pay attention to what's going on up here. They don't have to do anything. They don't have to provide you any information. They don't have to provide you any testimony. They can just sit there and completely tune out if they want to. You understand that that's Mr. St. Clair's right. Okay? And if he does that, if he chooses not, well, I doubt if he's going to play hangman, but if he chooses not to testify, or if they choose not to put any witnesses on, you understand that that does not change the presumption of innocence. He carries that with him through the entire trial, regardless of what he does or does not do, until it's time to deliberate. And then you apply that reasonable doubt standard to each element that Mr. Young has the burden to prove. Are you comfortable with that? Okay. All right, my last question. Do any of you have any reason, religious, just personal, strongly held personal beliefs or opinions, any reason why you cannot sit in judgment of Mr. St. Clair today? No. Okay. All right, I'm going to turn you folks over to the attorneys for questions.
All right, members of the prospective jury or prospective members of the jury, however we want to call it, thank you again for coming here today. My name is Robert Young. I represent Sumter Township and is clearly, should be known by now, I'm the prosecuting attorney in this matter. It's my opportunity just to ask a few questions, just to have a sense as to what your background is, maybe a little bit, and I don't get into much here, but just a couple that I think are important. So I'm going to ask it to all of you at once. I'm not going to focus in on any particular juror. And if there's something that you need to tell me about regarding the question or what you think I might need to know, I would appreciate it. And we'll get through this quick. Now, I've been the attorney out in Sumter since about 1989. So I've been there a long time. Things were different when I first started, but I've been honored to represent this community that long in a lot of different matters, and certainly as the prosecutor. Since I've been out there that long, I guess the question is, have any of you ever had any interaction with me for any reason? I'm involved in the civil matters. I'm involved in matters before the township board, not just related to criminal matters, but have our paths crossed at all personally over the last 35 years that any of you may recall? If your paths crossed at all with Detective Lieutenant Pulowski, who was sitting next to me there, for any reason? It doesn't have to be criminal in nature, but just for any reason at all? No. Have you had any cause or reason to have contact with the Sumter Township Police Department or say any of the elected officials in Sumter Township for any reason? I know most of you don't live there, but oh, you do. I'm sorry.
I do live 3 houses from the police department. I know people that work township office.
By your interaction at the township?
Well, friends that work there.
Who do you know?
I go on to Howard.
Okay. She works in the clerk's office, right? All right. So you have interaction with the clerk's office because you live in the township. You may go in and take care of whatever business that is before you. You don't socialize with anybody in the township for any reason, do you? I'm talking about the township hall offices. And the same would apply for the elected officials. All right, and I didn't mean to suggest that nobody lived in Sumter Township, because I did see the addresses of the respective jury pool. I know some of the entire group lived in the township, but for the most part, most of you live outside. This is an important question. You might look at me with a bit of a strange look, but have any of you had the benefit of reading the Belleville Area Independent newspaper? Do you know what that is? All right. And may I start with maybe juror number 2? When you've read, I guess I should say, the Belleville Area Independent newspaper, have you, or do you recall, or do you specifically remember any stories being printed in there about the Sumter Township Police Department?
You know, I read the court activities and things, but I don't.
All right. You don't read the opinion section or letters to the editor for the most part?
Right.
No recall, okay, you don't recall any specific references to the Sumter Township Police Department in any way? Sir, juror number 4 is you indicated that you also have read or do read the Independent from time to time. Same question. You recall any stories or any letters that have in any way addressed the Sumter Township Police Department in any manner?
Nothing specific that I recall.
All right. And did I see maybe one more? Yes, ma'am, in the back, juror number 6. Can you help me with that?
Yeah, I don't recall.
All right.
And I haven't read it.
Okay. And just to bring a little levity to this, you haven't read the paper where they demonized me in any way, have you? Okay. Well, that's a first, but thank you. And I think you indicated that neither or none of your family or friends are closely involved in law enforcement. Are any of them involved in any defense or criminal defense operations, being in an attorney's office or in any way with the court in any way? And do any of you have any personal biases or concerns that you can tell me about with the police in general? I mean, we know what I'm talking about, right? We've heard that there are complaints that have come out from time to time over a long period of time. This is nothing new, but specifically over the last few years. And I guess I need to ask if there is anything that you've read or any beliefs that you harbor, any thoughts that you have that would in any way shed any negative light. I'm not looking for good light. I'm just asking if there's any negative light that's at all focused on officers in general. Are any of you involved or your family members involved in any advocacy groups of any kind? Now, you heard the judge address to some extent the burden that is placed on me. And some of you have had the benefit of living through that burden before in terms of knowing what's going on. I accept that burden, and that burden has been defined. It's beyond a reasonable doubt. And we'll have an opportunity to talk about this more during the opening and during some of the evidence and then during the closing. But if I prove the case to you beyond a reasonable doubt, as that definition is defined, is there any reason why you couldn't return a verdict of guilty? Is there something that would prohibit you to return a verdict of guilty, notwithstanding the fact that I did my job from the standpoint that I proved to you beyond a reasonable doubt that this crime occurred? Last question. Is it you? I believe that this is, based on the answers I'm receiving, does anybody have a problem at all? I'm sorry, ma'am, you keep looking around. I'll try to move on. Does anybody have a problem at all following the court's instructions? When this case is over with and the facts are in, you'll be given instructions by the court as to what rules and what law to apply. Do you take that serious, and do you have any reason that you can share with me now that would prohibit you or prevent you from following the directions of the court as it relates to the burden and the outcome of this case? All right, I thank you for your time. I apologize if some of these questions were a little personal in nature. I guess they weren't too bad, but it's necessary. So thank you very much.
Mr. Jadala.
And good morning, ladies and gentlemen of the jury, proposed jury. I'm just going to be very brief. Does anyone here believe that a police officer testifying is automatically telling the truth because he's a police officer? Does anyone believe that a person who's maybe objectionable, opinionated, maybe a loudmouth, should be judged differently than someone who maybe is not of that nature? So everyone here agrees that regardless of what your attitude or your character may be on the external, you should be still judged as the judge addresses you. Is that correct? Thank you, ladies and gentlemen.
Thank you, gentlemen. Mr. Young, for cause from the people?
Your Honor, no challenges for cause. Thank you.
And Mr. Jadala, for cause?
None for cause, Judge.
How about peremptories from the people, Mr.
Your
Young?
Honor, the township is satisfied with the jury as it sits. No challenges.
And peremptories?
Defense would concur, Your Honor.
Wow. Now you folks have dodged the bullet. We have a jury. But before you leave, folks, I'm going to ask you to take another oath, last one of the day. Raise your right hands for me, please. Do you each solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? Thank you. Now you can leave. Folks, if you need a letter that shows you were here today, check at the security kiosk on your way out, and the guys will take care of you there. If you'd like to stick around to just see what happens today for another 10 minutes or the whole day, whatever, it's an open courtroom, you're free to stay. Last thing I wanted to, well, two things actually. May 3rd is our 3rd annual community day. We're hosting 354th graders. Wish us luck. Between 9-ish and noon. And then at noon, we open the community day up to the community at large. So we're going to have, I think, 5 food trucks. We'll have representatives from some of the police and fire departments. Last year, we had a smokehouse. I think they're confirmed for this year. We had, in the past, we've had bomb dogs. We've had the bomb robot from the airport, mounted patrols, canine units. We did give tours of the building. It's really a nice day, especially if we get a day with weather like this. So I'll invite you back for that. And then lastly, I promise this is the last thing. We love visitors. So we're heading towards summer vacation, and a week into it, you got those kiddos at home that are bored. Bring them up here. Just when you check in at the front with security, just ask them if there's any live stuff going on and where we're at. We love to have visitors, and time permitted, we'll actually give the kids a little private tour. So with that, you're free to leave, you're free to stay. Officer Crova, your turn. Do you swear that you will, to the best of your ability, keep sworn jurors in some private place, you will not allow anyone to speak with them, and that you will not speak with them except under the court's order, and specifically, you will not ask them if they've reached a verdict? Until they are discharged, you will not communicate to anyone the state of their deliberations or verdict they've agreed upon?
I do, so help me God.
Thank you. All right, folks, I'm going to continue reading to you. I'm now going to explain some of the legal principles you will need to know and the procedure we will follow at trial. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. To prove the charges, the prosecutor must prove the following beyond a reasonable doubt. Oh, this is where we need to insert. So give me a minute. I got to bounce around on my iPad. Oh, you know what? Let's do that. While I bounce around, would you front row folks hand all those out? Everybody gets an iPad. Everybody gets a steno pad. I'll explain those in just a minute. Do they still call those steno pads now that there's no such thing as a stenographer? What do they call those now? Notepads? Notepads. Hand out the blue notepads. All right, so folks, the notepads, that's kind of obvious. Those are for you to take notes if you wish to. Inside the notepad, you'll find a question form. And I'm going to give you a formal instruction later, but you folks are allowed to ask questions. Actually, I'll tell you now and then I'll skip it later. So when the prosecutor and the defense attorney are done with a witness, they finish their questioning of a witness. If you still have a question in your head that didn't get answered during that process and you think it's an important question, you can present that question to me. So you fill out the form, catch my eye, catch Officer Crova's eye, Heather's watching around. I'll look at that question. I'll either contact or bring the 2 attorneys up or have it passed around. We might have a discussion of whether or not we think it's a good question as written, or it can be made into a good question. When I mean good question, admissible evidence will be solicited by the question. If the attorneys and I agree it's a valid question to go forward with, I'll present that question to the witness that's still in the witness chair. If I don't think it's a good question, I'm not going to present it. We'll move on, and then later I'll explain to you what there was about that question that caused it not to be asked. So the question form and the notepad, don't use them if you don't want to. All right, I'm a note taker. I always thought it was unreasonable. If I take notes during a trial, I always thought it was unreasonable that jurors could not take notes during a trial. So I was happy when the Supreme Court of Michigan pretty much said, hey, give them a chance to take notes. But once again, if you don't want to take notes, if you find that distracting, then just close that pad and don't worry about it. Similarly, the tablet in front of you. I told you I'm reading criminal jury instructions. You can read along with me. I'm a visual learner. Somebody reads something to me, my eyes roll back in my head, and it doesn't work for me. I want to see things for myself. So if you want to follow along, you can, and I'll walk you through that in just a second. If you don't, then just put that tablet down and ignore it, and just listen to the melodious sound of my voice if that's what makes you happy. So currently, I'm in procedural instructions on the tab. If you play around, if you're having trouble, just let us know. And I'm going to read to you the elements of the crime that Mr. Young has the burden of proving to you today. Interference with the police. It shall be unlawful for any person to resist lawful arrest or interfere, either directly or indirectly, with an officer making an arrest. And I think from your earlier comments, Mr. Young, that's where you're satisfied with me stopping. And not going on to the refuse to assist language.
Maybe I misspoke. What I was suggesting to the court, if you look, we were referencing at that time the complaint.
Right.
And we had referenced both the local ordinance and the state statute. And what I was trying to indicate to the court is that the only matter that we have agreed to proceed on is the local ordinance at this time. So the entire ordinance is what I'll be talking about, although it'll become clear as we get into this, that really the last half or the latter part of the ordinance is what's relevant. But I just asked the court to read the whole ordinance, and then we can deal with it if your honor pleases.
Okay.
All right.
Yeah. It shall be unlawful for any person to resist lawful arrest or interfere either directly or indirectly with an officer making an arrest, or to refuse to assist an officer upon being commanded by the officer to give assistance, or to refuse to disperse upon the command of an officer, or to object, resist, hinder, or oppose any officer in the discharge or apparent discharge of his duty. Now going back to the procedural instructions. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defense attorney may also offer evidence, but does not have to do so. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has a right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defense lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You've been given a written copy of the instructions with the tablet. You may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of the final instructions for your use during deliberations. Function of the court and jury. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the other. You are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It's your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, You should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that may affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. Oh, I skipped one, I'm sorry. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. You should then discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss this case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It's very important that you only get information about this case in court when you are acting as a jury and when the defendant, the lawyers, and I are all here. Do not go to the scene of the alleged crime. Do not investigate anything about the case on your own or make any experiments. Do not search the internet on your phone to assist in understanding the evidence in this case. I've already explained about taking notes. Number of jurors. You can see that we've chosen a jury of 7. After you've heard all the evidence and my instructions, we will draw lots to decide which one of you will be dismissed in order to form a jury of 6. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all of the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make any decision about anything in the case until you go to the jury room to decide. I'm assuming you guys are ready for openings. Okay. Folks, I'm going to give you a chance to take a break right now before we get started with the attorneys. If you don't want to take a break, that's all right too. And I also want to let you know that you set the schedule today. So whether or not we break for lunch and when we break for lunch, that's your decision within reason. If we get towards the end of the day and it looks like we might not be wrapping up by what I consider to be an end of a business day, like a 4 or 5, you folks will decide if we're going to work late or not. I'm not going to decide that. You'll decide that. So just start thinking about those types of things so that when you take a break here and there, you can have a group discussion, decide about lunch and so on and so forth. Are you okay to keep working now, or do you want a little break? Keep going? Okay, all right, opening.
Thank you. All right, ladies and gentlemen, now of the jury, again, Robert Young is my name, Sumter Township prosecutor, the one whose responsibility it is today to prove to you beyond a reasonable doubt that the defendant in this case committed a crime that occurred on January the 6th, 2023. Before I get into this, I just want to again thank you for being here. As the court indicated or suggested earlier, this is an imposition on all of you. You get hustled down here, you get set in a room, you come in here, we ask you a bunch of questions. And what we're really doing is we're asking you to help us resolve a dispute or a disagreement that we can't resolve ourselves. It's the process. It's been around since 1791. I don't expect it to change soon. I hope it doesn't change soon, because anybody who is called to answer for a crime in this country has the ability to have a jury of his peers or her peers adjudicate and decide if in fact the prosecution has proven their case beyond a reasonable doubt, which is no different than what we're asking you to do today. The ordinance that the township is bringing this action under is lengthy, in the sense that I'm sure that none of you could repeat it, probably didn't understand it. And since it was put fully in the record, which is what I felt I had an obligation to do, I'll tell you specifically what I expect the proofs to show and what the focus is going to be. Now, my case today will be through the testimony of, for the most part, of Sergeant Belowski. Now, I've referred to him as Sergeant Lieutenant. I've referred to him as Sergeant. And let me just give you a quick background and what I expect the proofs to be so that that confusion can get resolved quickly. When this incident occurred, he held the position or rank of sergeant in the township. Shortly thereafter, he was given a promotion and held the position of detective sergeant. And now recently, he's been promoted again, and his position is detective lieutenant. So not to get confused, if you're looking at videos, which there will be at least one video to look at, I'll just call him Detective Belowski. And it doesn't matter what his rank is today in reference to this case, nor what it was back in January of 2023. I'm just trying to clarify if there's a misstatement or what you might think is a misstatement. He's held the position, a number of positions over the last year and a half, basically. He will be the officer in charge. He will be the officer that you will hear. He will be the officer that you will hear testimony from today first. He will also be the officer that will have some comment and explanation as we look through a video of the events that occurred on that day. Now, I'm going to give you just a kind of a quick overview as what I expect the proofs to show. As the court indicated, these are not facts. I don't present facts to the jury myself. The facts come from the witness stand and come from any other exhibits that you might have the benefit of reviewing. Certainly the video you'll have the benefit of hearing. But we have no objection, and we wouldn't have it any other way, that what the attorneys say here today are not facts, but just merely some background information, at least in the opening, as to what to expect. I expect the proofs to show, first of all, that the township will show that there was a violation by the defendant of all the elements contained in the Sumter Township Code 14-27. You heard that was read to you earlier by the court. Well, let me simplify it for you. It shall be unlawful for any person to obstruct, resist, hinder, or oppose any officer in the discharge or apparent discharge of his duties. Now that's pretty direct. There's also a portion in there that talks about the failure to disperse upon command of an officer, which you will see and hear some testimony in relation to that, but primarily the case is brought based on the last portion of that township ordinance, which is, again, it's unlawful for any person to obstruct, resist, hinder, or oppose any officer in the discharge or in the apparent discharge of his duties. Now, all that being said, what do I expect to show? I will show you, and I expect the proofs to show as it relates to all the matters that are presented, that on January the 6th, Sergeant Belowski was on patrol approximately 10 o'clock at night. Sergeant Belowski will testify that a particular vehicle was brought to his attention. I'll let him describe what his impressions were. I'll let him describe what action he took thereafter. But in any event, the proofs will show that after a series of surveillance turns and twists, his car came to rest near Sharon Court and Willis Road and Sharon Court intersection in Sumter Township, County of Wayne, and State of Michigan. And the vehicle driven by the defendant came to rest about 150 feet away. The proofs will show 10 o'clock at night. We have one vehicle facing one way, and we have Detective Belowski's vehicle facing another way. Detective Belowski will testify why he believed that the passenger of that vehicle, a gentleman by the name of Paul Dupont, had outstanding warrants, was involved in certain drug activity, and it was his purpose and intent when he was conducting the surveillance at that time not to be concerned with the defendant in this case, not to be concerned at all with Mr. St. Clair. In fact, the testimony will be that he never met, he didn't know, that he never had any contact at all with Mr. St. Clair up until that point. His focus and attention was on Mr. Dupont for the purpose of effectuating an arrest warrant and to investigate whether or not crime was afoot as it relates to the sale of narcotics. Interestingly enough, and you will see this in the video, as Detective Belowski's vehicle comes to a stop, you can see the vehicle 150 feet down the road. Somebody exit. You don't see it clearly, but the testimony will be that who was ever in that passenger side, turns out to be Mr. Dupont, exits the vehicle, and believe it or not, begins to walk toward Detective Belowski. When he gets about halfway there, Detective Belowski will indicate to you that he recognized him as Paul Dupont, got out of the vehicle. Testimony will be is before he got out of the vehicle, and you will see the lean machine running where he was checking to determine and see what outstanding warrants there were at that time as to Mr. Dupont, which he confirmed there were. His testimony will be when he got out, his intent was to arrest Mr. Dupont and take him in on those warrants, something that is pretty standard in police activity. And then the incident begins. While he's engaged with Mr. Dupont having a discussion about certain things, that vehicle 150 feet away pulls up, and comes in within close proximity of where Detective Belowski is engaged with Paul Dupont, asking him questions and beginning to effectuate the arrest. Testimony will be that neither Sergeant Belowski, nor, as best we can tell from the video, again, which you'll have a chance to look at, nobody directed that vehicle that we came to find out was driven by the defendant in this case. Nobody asked, nobody directed, nobody requested that vehicle to pull forward. At that time, there was no interest in that person, the testimony will show. When the vehicle pulled forward, the defendant in the car rolled down the window and the exchange began. And the testimony will be, or at least what you will see when it comes to the video, there was a period of about 10 minutes back and forth where the testimony and the evidence will show that Mr. Belowski, Detective Belowski, was unable to complete the arrest given the fact that he was focused on the defendant who was hurling obscenities at him, who admitted that he had a gun on him, who became agitated. And you'll hear specific testimony from Mr. Belowski as to why he had to act the way that he acted. He called for backup. You will see one officer arrive for backup, and you will see Detective Belowski holding on to the defendant that or excuse me, Mr. Dupont, who he just arrested. And you will see him not leaving the scene. And he will explain why that happened. And he will explain why when the first officer showed up, he continued to engage or to have this discussion with the defendant. You will hear, if you keep count, Sergeant Belowski direct the defendant to leave the scene over 30 times. His focus was not on the defendant. His focus was again on arresting Mr. Dupont. As you might understand and guess, of course, the defendant did not leave the scene. Second police officer showed up. Now he felt that he had the situation under control, at least to the extent that both officers were there. You never leave one officer alone and go complete the arrest. Testimony will be that he would have had to taken Mr. Dupont away from the scene, pat him down, do an inventory search before he put him in the car. These are things that are standard. But he couldn't do that because he was strapped with dealing with the interaction and what we contend to be the interference, the obstruction, the hindering, and the resisting of the direct order given by Officer Detective Belowski to the defendant, Mr. Dupont. And the good thing about this, I guess, from a proof standpoint, from both maybe the prosecutor standpoint and the defense standpoint, is that it's there for you to see. And this is a chest cam view. So what you will see is you will see what is happening through the lens and through the eyes of Detective Belowski. And you will understand with his testimony, and I expect the proofs to show that which occurred and why these charges were brought. Now, I asked you during some of the questions with the jury selection, and you were instructed by the court, when this is over with, after all the proof is in, then I'll have a chance, as Mr. Jadala will, to address you again. And at that time, we can be a little more specific as to what we think the proofs did in fact show. We can argue, not with you, but we can present to you our arguments as to why, in my case, I believe that a verdict of guilty should be returned. And Mr. Jadala will give those arguments on behalf of his client as to why a verdict of not guilty should be given. So I'll have that opportunity to speak to you again, but between now and then, I just ask you, if you would, to listen to the evidence, all of the evidence. I have as much belief that the defense has the right to present whatever evidence that it or he or she wants to present. It's the way it is. I'm not afraid of the evidence. I welcome the evidence. And when it's all over, we'll have an opportunity to discuss that before you retire to deliberate and to reach a verdict. I thank you for giving me the time to at least give you this overview. And I look forward to addressing you again at the end of this trial. Thank you.
Now or later?
I'll do now.
Thank you.
As a child, I remember being in trouble a lot with my parents. And I remember when I would come home to face the music, my dad would look at me, scream at me, and tell me, go to your room. And I would get up to go to my room, and he'd keep talking to me. Look at me when I'm talking to you. And I'd be confused. Do I go to my room, or do I keep listening to him? Those mixed messages sometimes would make my brain think, do I do what I'm told, or do I hold on and wait? What you're going to see is that there's going to be lots of mixed messages when you watch the video. We're going to acknowledge that, yes, Detective Berlowski did tell my client to leave, maybe 30 times. But actively, you will see that he was being accused by the sergeant, by the detective, of active crimes, telling him, you did this, you did this, you did this. You're also going to see that there wasn't really a safe path for him to leave. You're also going to see that my client never left his car. He never interfered, he never interjected, he just stayed still. You're going to see that there was lots of mixed messages when you watch the video, despite what the sergeant's going to testify to. It's fine, you can tell someone to leave, But when you're actively engaging in a conversation with him, you're sending mixed messages. Thank you.
Ready for witness?
Right there.
Who's first?
May I, we have the video, so I just want to make sure that we have that ready. We know how to do this. Okay. Gonna recall Detective Belowski?
Rant. Swear affirm, tell the truth, the whole truth, nothing but the truth. Settle in. Mr. Giselle, I've got about a gallon of those if you need.
Thank you, Judge. I do have one more. It's been a month and we're just both talking about it. I've been trying to fight the sinus infection, so I apologize. I appreciate that. Thank you. I'm good.
I'm same sinus infection. I mean, I can't breathe. I'd like to have.
Thank you, Ed.
Thank you.
Is it right to start?
Yeah.
All right. Detective, tell the jury who you are.
I'm Detective Lieutenant Joseph Belowski. I serve with the Sumter Township Police Department.
You currently hold the rank of Detective Lieutenant. I talked a little bit about that during the open.
Yes, I do.
Prior to that, you were the Detective Sergeant.
Yes,
And prior to that, on the date of the incident, your rank was Sergeant.
I was a road patrol sergeant.
How long have you been employed with the township?
I've been employed with Sumter Township since April of 2013.
And as a road sergeant, your duties consist of what normally?
Patrol activities, apprehension of criminals, investigations, and supervising other officers in their daily patrol duties.
Now, let me direct your attention to January 6, 2023. You remember that date, right? That's why we're here today.
I do.
And did you have reason or cause approximately 10 p.m. that night to come into contact or to be made aware of a vehicle that you thought was suspicious?
I was on patrol in a fully marked patrol unit in uniform. And I was traveling eastbound on Willis Road when I noticed a dark Explorer parked in the area of Sharon Court and Willis Road at a institution called the Liquor Wagon. I observed this vehicle. I saw that it had a unit number on the front bumper of 921, and I continued past it going eastbound on Willis Road. Once I was heading eastbound on Willis Road towards Sumter Road, the vehicle started to travel behind. I briefly pulled over thinking it was another patrol vehicle of a different agency attempting to speak with me. At that point, I pulled over. The vehicle started to pass me. It made a right-hand turn going from eastbound Willis Road to southbound Sumter Road. At this point, I noticed that the plate was not a municipal plate. I conducted a lean SOS check, which is a law enforcement information network check or Secretary of State check of the Explorer's license plate. That revealed it belonged to a regular citizen, of course, and listed as Travis St. Clair. I observed that vehicle, and then I realized from a shift brief that I had with Officer Johnson that I was told about this vehicle.
Let me stop you. Now, up until that point, you had no reason to believe that Paul Dupont had anything to do with this vehicle?
No, I had reason now to believe that Paul Dupont had contact with this vehicle.
All right, I guess what I was getting at before, you had a chance to identify this vehicle that looked like a police vehicle. You had no idea that Paul Dupont was in the area. You had no idea that Paul Dupont was the passenger in that vehicle.
No, I did not.
All right. And at what point was it that you started to process the possibility that Mr. Dupont was the passenger in that vehicle?
So as it makes that right-hand turn to go south on Sumter Road, I was thinking it was a patrol vehicle of a police agency, and realizing it wasn't, I remembered that I had a shift brief with Officer Johnson of the Sumter Township Police Department, explaining the event that occurred on his prior shift.
All right, so you're
not prior exactly, but a prior shift.
Officer Johnson holds the position of patrol officer.
Correct.
You were a sergeant at the time.
Yes.
Is it your duty and responsibility, or one of them, that you interact with your road patrol officers, debrief them, have discussions about what incidents, if any, they've faced and that they wanted to deal with?
Correct. And it's part of the learning procedure.
All right, and so at some night or at some time before January the 6th, you discussed with Officer, I believe you said Johnson,
That's correct.
where he had an incident that involved a vehicle that resembled a police vehicle.
Yes,
And- Go ahead.
he told me that he had contact with a lookalike police vehicle. And during that interaction, the subject was hostile. And that also during that interaction, they had contact with Paul Dupont. Paul Dupont is known to me and many members of the department to carry out standing warrants and to be involved in narcotics such as cocaine.
Based upon that information, you're processing that which you heard from Officer Johnson. Did you continue the surveillance?
I did. I continued to follow the lookalike patrol vehicle southbound on Sumter Road. It made a right-hand turn to go east on Judd, and then it went into the Fenster sub. The Fenster subdivision is a small subdivision in Sumter Township where it's more residential than agricultural or rural. And at that point, I had kind of lost sight of the vehicle.
What happened next?
I continued to look for the vehicle while conducting a lean SOS check of Paul Dupont, which revealed that he had multiple outstanding warrants, one of which was from Lincoln Park for synthetic narcotics.
What is a lean SOS system?
Lean is the law enforcement information network, and SOS means Secretary of State. So as a police officer, I can run people's plates, conduct name searches, which would reveal whether their plates expired or whether they have warrants or whether their driver's license is valid, such activity like that.
And is it my understanding that your testimony is that you did that to check the status of any outstanding warrants as it relates to Paul Dupont?
Correct.
And what did your review show?
The review revealed that Paul Dupont had a warrant out of Lincoln Park for synthetic narcotics, along with many other warrants.
All right, at that moment, when that became known to you, was it your purpose and intent that if you had the opportunity, you were going to arrest Mr. Dupont for those outstanding warrants?
Correct.
What did you do next then?
Mr. Dupont lives on Sharon Court himself, where I first observed the vehicle, and I continued to surveil the area for the vehicle. At one point, I did pick the vehicle back up, making a turnaround in a driveway on Reed. And I attempted to start following that vehicle, but again, lost it when it doubled back, going back eastbound on Judd Road.
All right. Ultimately, though, you came in contact where both vehicles were stationary and you were facing the front of your vehicle was facing the front of this lookalike police vehicle that you've referenced. Is that right?
That is right. I went back myself towards the area of Willis and Sumter where I had first ran the plate, and observed the vehicle at the Sumter Market. I was going to pull into the area of Sumter Market and see if Mr. Dupont was the passenger. However, the vehicle started to move again. It exited the parking lot, going westbound again on Willis Road through the intersection of Sumter, going back to Sharon Court and turning down Sharon Court, heading south on Sharon Court to where Paul Dupont's registered address is, at the 19,000 block of Sharon Court.
The vehicle came to a stop. Your vehicle came to a stop. The separation between the two was approximately 150 feet.
That's right. The vehicle was now pointing northbound on Sharon Court because it did kind of like a U-turn. And I had pulled in, still trying to surveil the vehicle, no emergency lights, just pulled in to an abutment area of the liquor wagon parking lot and Sharon Court.
All right.
So at that time, I wasn't blocking Sharon Court.
All right, after going through this maze that you just described and the reasons behind it, when your vehicle came to a stop, pointed at the vehicle that was 150 feet away, at that time, did you know who was operating that vehicle?
I did not know at that point who was operating the motor
At
vehicle.
that time, had you had any prior contact or engagement with the defendant?
I had never, to my knowledge, met Mr. St. Clair before.
Did you ever have any phone conversations or other means of communication with him that you recall?
No.
Your focus and intent or purpose at that time was Paul Dupont?
It was, and the operation of the motor vehicle was suspicious in and of itself.
All right, what happened next?
As that vehicle did its turn and was pointing north, a large male exited the vehicle, the passenger side door, and the male started to approach my patrol vehicle, which, as you said, was over 100. I would approximate over 150
When you
feet
say
away.
approach, was he walking?
The male exited the lookalike patrol vehicle and started to approach my patrol vehicle. He was carrying a bag and a cell phone that was illuminated as like a flashlight.
Were you able to identify the person walking toward you as Paul Dupont?
I exited my patrol vehicle because I don't allow people to approach me in the seated position, especially if they're suspicious. And I exited my patrol vehicle, and once Mr. Dupont got a little bit closer because it was dark and was illuminated by my headlights, I could verify it was Mr. Dupont.
When you verified it was Mr. Dupont, again, it was your purpose to effectuate the arrest warrant that was outstanding as to him for whatever the outstanding charges or reasons were, is that right?
That is correct.
By the way, is that one of the duties that you have as a police officer?
Yes,
If there's a warrant outstanding, that warrant is in order to make the arrest of whoever is the subject of that warrant. Is that my understanding?
correct.
You've done that many times
Hundreds.
and probably will continue to do that as time goes on in your career. Is that right?
Yes.
All right. So at that point, you're getting close and you're gonna have an engagement or something with Mr. Dupont. What happens to that other vehicle? I'm talking about the vehicle that was 150 feet down the road.
Initially, it stays the 150 feet. I start speaking to Mr. Dupont. He says that he's coming up to say hi, and I start having an interaction with him. As I start having that interaction, the vehicle, the lookalike patrol vehicle, starts slowly rolling down to my location.
So that vehicle rolled, drove, traveled the 150 feet up to where you were located and you're engaging with Mr. Dupont at that time?
That's correct.
Do you recall if anyone directed or requested that vehicle to move forward?
Not that I'm aware of.
Do you have any reason or understanding as to why that vehicle moved forward at that time?
I could only speculate.
All right. What happens next?
I order Mr. Dupont that he needs to put down his bag. He's carrying a grocery bag.
Why would you
and-
do that?
Because I'm gonna handcuff him.
You're going to effectuate the arrest by using handcuffs?
Correct.
All right. What happens next?
Mr. Dupont looks nervous. He advises me that he was just coming up to say hi. I order him back to me. I tell him he's being placed under arrest and put the bag down. And he doesn't immediately comply. The vehicle is now very close to our location now with the passenger side window rolled down. Mr. Dupont looks over and he takes his bag, walks over to the lookalike patrol vehicle and places the grocery bag inside the open window of the lookalike patrol vehicle.
Okay, let me stop you there. I'm going to use the video here in a second. At that moment, are you the only police officer on scene?
I am the only police officer there.
Have you requested backup at that point?
I have.
And of course, didn't arrive yet, but you were the only officer at that moment, right?
Correct.
Can, Your Honor, with the court's permission, we'd like to start the video. Joe. No, not you, just, can you get out? And I'm gonna stop you if you can, when we move this. We just saw that system there that's moving to the right. Is that the Lean SOS system you're talking about?
That's called Talon, and that's
Okay.
how we access Lean SOS, which is Law Enforcement Information Network, Secretary of State.
Are those systems in almost all police vehicles today?
Yes, anyone that has what's called a mobile computer, most have some form of information network system to check warrants.
So you're not required to call into the dispatch or to the office anymore to find out if there's an outstanding lien. You can just look on the system.
Correct. I knew Mr. Paul Dupon's name and date of birth, punched it in, and it told me that he had warrants.
And by the way, all of this is happening in Sumter Township, County of Wayne, and State of Michigan on that date, right?
That's correct.
All right, so you determined that there was outstanding warrants. So at this point, you were able to determine that's Mr. Dupont that we've been talking about for the last 10 minutes? And the
Yes.
bag that he's carrying, that's the bag you're referencing?
That is the bag I am referencing.
And I can see the lights appear to be starting to move this way.
That's correct.
Can you go back just a little bit? I just want to make sure we all understand where that car originated. All right, go ahead.
Are you know me?
Are you gonna drive down here?
So the vehicle that pulls up right there next to you, is that the same vehicle that we looked at down the road?
That is the same vehicle.
That's the vehicle that you reference as the lookalike police vehicle?
I say that because it has a push bumper, a unit number at the front plate bracket of 921. It has a light bar. It has blue decals on the back that I don't think you can observe here. And in the prior run, I was told that the caller who called on the vehicle was getting honked at by a non-regular horn that they thought was initially a police officer.
All right, that's the incident that you talked about when you debriefed Officer Johnson some.
That
days
is
before
the
this.
information that Officer Johnson debriefed with me.
All
Yes.
right. What was your thoughts when that car pulled up at that point? Anything?
I'm outnumbered. I'm outnumbered by Mr. Dupont, who's clearly a bigger guy. I have what I consider to look like a patrol vehicle. I'm now a detective in my patrol vehicle, while my take-home detective vehicle looks less like a patrol vehicle than that.
That moment there, did you know that the occupant of that vehicle was Mr. St. Clair?
No, but I had suspicion.
Only based on your discussions with Officer Johnson when you went through the debriefing?
Based on the discussion with Officer Johnson and that the vehicle was registered to Mr. St. Clair.
Okay, go ahead.
All right, get back over here. You got warrants. Go ahead, clear your stuff down, face around.
I just went to jail.
I told you.
I just went to
Come
jail.
on, I'm gonna see if you got drugs. Stop what you're doing, put your stuff down, face around.
Why,
You got
why,
warrants.
why am I being searched?
Cause you're getting searched, cause you got warrants. No, you're not.
All right,
Hey, man.
so you directed him to put the bag down and to come forward. You're going to search him and place him under arrest. Now, we watched him defy that order or that directive or that request, whatever you want to call it. And he moves to that vehicle
Yes.
and he puts the bag into the vehicle. Right?
Yes, he does.
Why didn't you go towards the vehicle and pick up the bag, the evidence from the arrest that you're effectuating right now? Why'd you stay back?
Because I need to deal with Mr. Dupont.
All right, but Mr. Dupont is moving towards the vehicle.
Yes.
Why don't you go pick up Mr. Dupont at the vehicle, pick up the bag and call it a day?
I didn't have that opportunity.
All right, continue.
I got nothing, no problem with you, but don't touch that bag, because he was under arrest and you something. I'm not, I'll wait. Hey man, I got nothing, no problem with you, but don't touch that bag, because he was under arrest and you something. I'm not, I'll put your hands on your bag, put your hands on your bag. Put your,
That's not- So when the vehicle pulled up and the window was rolled down after, or before, I guess I should say, and Mr. Dupont puts the bag in there, something you want to see. The first words out of your mouth are, I have no problem with you, just don't touch the bag.
That is correct.
Why, are you entitled to that bag at that point?
I believe so.
Evidence based on what your investigation was, and it was coming as a result of an arrest that you're about to make.
That's correct. It would normally, if it was still on his person, it would be search incident to arrest.
All right, so your first words in life with Mr. St. Clair was, I have no problem with you, just don't touch the bag.
That is correct.
What was his response?
He told me that I'd been harassing and stalking them.
Continue.
That's fucking big deal. And stop. You know.
big problems you got with your friend.
So I come up and say hi. Are you gonna pay me a fucking bill?
No, I know.
You guys, supervisor, please.
I am the supervisor, sir. You're in.
So at that moment, you've got Mr. Dupont. Why didn't you leave the scene?
Because I was trying to conduct a narcotics investigation, and at that point, due to his demeanor, I believed that it was in the bag at this point.
All right, so was your purpose then was to go get the bag?
It was.
All right, so that was the reason you didn't leave at this point. You had your guy, he was under arrest, but you wanted the evidence.
Correct.
Continue.
A vehicle that looks like mighty like a lot of patrol car, you can't shine that in my face. Actually, I can. Do you have your driver's license on you, sir? I am the supervisor, fool. You got a gun on you? You got a gun on you? Asshole. Give me your CPR.
All right, stop. So at that moment, you're asking him to provide some sort of ID and proof of the right to carry, is that right?
That is right. I'm concerned because as I'm effectuating my arrest, he's still having that banter. And when I turn around and I illuminate the vehicle, because it's an officer safety issue to not know what's inside of a vehicle, it's common practice to illuminate the interior of a vehicle.
Okay, when you flash your light inside, then what you're saying is you want to see what, if there's weapons around?
That's
He
correct.
indicated that he was armed.
Yes.
All right, I guess what I want to know is aside from the bag, was there any reason you couldn't leave the scene at that point?
At this point, no.
All right, now you're gonna make a further step to get the evidence, right?
I'll show you, but I can't do shit. I'm not ready yet.
Don't reach. Put your hands on the steering wheel. Put your hands on your steering wheel. Do it now. You call the chief. This is ridiculous.
Yeah, it is. I'm not doing that.
No, it's not my vehicle. He was under arrest.
So we heard Mr. St. Clair, the defendant in this case, scream, "Do not reach into my vehicle." What happened? What precipitated that response?
At this point, I can tell that he's not going to be compliant with letting me retrieve the property. And due to the exigent circumstances of it being a vehicle that can just drive away, I recovered the property.
When you say exigent circumstances, you mean that if the vehicle drives away, the opportunity to recover that evidence is gone?
That's correct.
It's not as if it's located in a house where you can go get a search warrant.
That's correct.
So that was what conclusion you came to at that point, that you'll retrieve the evidence as you did at that moment?
And it was to retrieve the property, and if he was not going to be compliant, I would order him away.
Right.
As he's already shining the flashlight in my eyes, so I couldn't see.
You can leave. You can leave. You can leave. You can leave. Go ahead. Go ahead. Policy number 3. If you don't get out of here, you will be placed under arrest. Go. Go or get placed under arrest.
So detective, at that moment, you've got Dupont at least cuffed. You've got.
That's correct.
Recovery of the evidence, or at least what you thought might be the evidence. And you've directed him to leave. I'm talking about the defendant in the car.
That's correct.
Was there a reason why you couldn't leave at that moment?
At this point, I need to search Mr. Dupont, make sure he doesn't have any weapons.
So search Mr. Dupont and see if he has any weapons. You
That's
can't do
correct.
that?
I cannot,
Tell us why.
because this is a hostile individual who's refusing to leave my scene, and he's armed, admittedly armed.
To your knowledge or to your understanding, was there any reason for this defendant to even be there at this time?
To my knowledge, he has no, other than to maybe drop off Mr. Paul Dupont.
Alright.
I don't know why he would need to stop.
So if I understand you correctly, you can't finish your arrest process, which is to pat him down, search the bag, find it to be secure before you put him in the patrol car, because it's just you and this hostile individual screaming at you out of the car who says he's armed.
That's correct.
What are we waiting for? Backup?
We're waiting for backup.
They're on their way, maybe?
I've already called for them.
All right. And what was your purpose, intent once backup was to get there?
To further my investigation into the narcotics.
Somebody, another officer could take over control of the scene, at least as it relates to the defendant. Is that what, about right?
Officer safety, so they could have contact. That way I could conduct my business without the fear of something happening from Mr. St. Clair.
All right.
Go or get placed under arrest. Do it now. Leave. Leave. 16 days. I got one to take.
Motherfucker. All I do is look and say, hi, why are you arresting me? I got words, yes. I was just in jail 2 weeks ago.
I'm the supervisor. On a Friday night, I don't think so. Stalking. Stalking. Listen.
So at that moment, you're engaged with this guy, same purpose that you can't leave, you can't complete the arrest, as I understand it, effectuate properly, protect your safety. You can't turn your back on that situation, I would assume.
I've made it very clear that I've ordered him to leave or be placed under arrest. Obviously, I cannot effect an arrest with Mr. Dupont in my hands and no other backup.
Let me ask you this, if Mr. St. Clair was not on the scene, would this have been just a normal arrest?
Mr. Dupont, other than placing his bag into the defendant's car, was compliant.
All right, so I guess my question is that if Mr. St. Clair was not on this scene right now and you came into contact with Mr. Dupont, you arrested him before, didn't you?
And he was compliant.
All right, so it would have been a typical arrest, nothing for us to talk about?
That's correct.
Continue.
You're in a patrol car. You're in a patrol car. Well, it sure looks like a patrol car. And if you're not leaving, then you're gonna need to identify yourself.
Hey. Oh, hey.
Obstructing my investigation. Obstructing a.
Now I see Mr. St. Clair, the defendant in this case, turned to his left and talked to somebody at his window. Do you know who that was?
Officer Johnson has arrived on the scene.
All right, so Officer Johnson was the first officer to arrive back up.
He's the first backup officer to arrive.
All right. And you're waiting for somebody else?
That's correct.
Why two?
Because I'm the supervisor, I'm not gonna leave Officer Johnson by himself with someone who I feel is unstable.
Unstable in what way?
I don't think that's a normal reaction to what occurred prior. He's armed, he's not compliant, he's defiant for an unknown reason.
Okay, so you stand there.
Obstructing my investigation. Obstructing my investigation. Then you need to leave. You understand that? You get over there, get over there. Keep an eye on him. then you need to leave.
So you asked Officer Johnson to come on the other side of the vehicle of the defendant's vehicle near you.
Mhm.
What was the purpose for that?
So we could both be on the same plane, of visual plane.
Okay.
And that way he didn't feel pressured to stay on scene.
All
When
right.
people surround vehicles, sometimes you feel that pressure that you can't move.
You want him to leave, fair statement?
I still want him to leave.
I asked you to leave. I give you an order to leave. That doesn't matter.
Can I talk to him? Can I talk to him real quick? Can I talk to him real quick, please?
No, you can't talk to nobody yet. Till this guy decides to leave. Let him out. Let him out. What's that gonna do? I am the supervisor. You're acting like you're a cop.
Was his ability to leave the area blocked?
It was not completely blocked at this point. Officer Johnson has pulled up and it's somewhat obstructed, but I give him commands briefly here to move his patrol vehicle. So
Did he do
can
that?
leave. And Mr. St. Clair has already said no.
I understand, but he was given, is there a clear path to leave at this point or not?
There is a path to leave, yes.
Okay.
You got a light bar, you got a gun on your hip, you got a light, you got a call box, you got a plate light out. Okay, leave. Now you're littering. Now you're littering. Litter.
So this encounter is going on and on and on while you're waiting for the other police officer to arrive?
That's correct.
So that he and Mr. Johnson, Officer Johnson, the two of them would be able to at least secure the scene while you now finally get to completing your arrest, search, and placement of Mr. Dupont in the police vehicle. Is that about right?
That sums up.
At that
Okay,
moment,
correct.
Officer Herrick had not arrived yet, right?
Officer Herrick is not on scene at this point.
Okay. Continue.
No, you didn't try to hand me anything. I got things with both my hands. You need to come pick this up. Come pick this up. Come pick this up. Go. Leave. Leave.
Hey,
Leave.
hey man, you're fucking throwing me around. This is bullshit.
No, you haven't moved at all.
Bullshit. I don't slip.
Leave
You
me
throwing me around.
The number is 4616898. You're gonna talk to me. Good for you. Why am I gonna find drugs? How about you stay long enough?
So what was your purpose and intent again for staying there at that point?
Officer Herrick's still not on scene. I still have not properly searched Paul Dupont. I don't know if he's armed. I don't know if he has narcotics. I can't just put him in the back of my patrol vehicle and leave if he's armed or has narcotics in there. That'd be a policy violation and unsafe.
Now, am I going to see Officer Herrick finally arrive?
I think it's coming up.
You find the drugs on him and then I search your car. Because that's what he came out of. Leave. Leave.
I dropped off.
Go ahead. I'm not a criminal.
Yeah, I'll get out of this one.
Get out of his life. There's gonna be drugs in it. I know that.
I said I leave.
You sold some weed.
I did.
Now you sold some weed out of your car. You
I
never had
did.
to get my message to railway. You waited in the fence to sub. Before you black out on me. I know what's going on here. You're gonna have to leave.
Excuse me, sir.
I am the supervisor.
Sir.
You can come in on Monday.
Please spell this
You can
out.
come in on Monday. Here.
I don't accept any.
Keep an eye on it. You're under arrest. I don't need.
So at that moment, had Officer Herrick just arrived?
Officer Herrick is just pulling on scene. As you can tell, Officer Johnson has moved his vehicle. However, unfortunately, now Officer Herrick has pulled into that same location.
Okay. So now that Officer Herrick showed up, you asked him to keep an eye on him, and then what we're going to see in a moment is you taking DuPont away from the scene and doing those things that you wanted to do 15 minutes ago.
That's correct.
Well, let's look at a little bit of that and then we'll.
Insane. He has a gun on him, he's acting like an
Why
idiot.
am I under arrest, man?
Yeah.
Why am I under
He
arrest?
has a gun on him, he's acting like an idiot.
I don't- This is bullshit, man. I just want to say, I got a knife in my right pocket.
Paul's saying that he may have just sold some weed out of his car, so.
I can still be on the car.
So that's the sub,
I put it over there, it's not selling, it's not illegal.
transporting.
It's not illegal if it's locked up.
Good. Yeah.
Is it your car?
It was locked up in the back.
Or you guys saw weed on a state patrol car?
No, I'm talking to you, Travis. No, I'm talking to you too. I got a knife in my right pocket. It's my work knife.
Okay, let's stop. So what we're looking at here, and we don't need to watch this unless somebody thinks it's important. This is when you're going through the boring stages of just inventorying what is on his possession, separating it from him, patting him down, and getting him ready to put into your police car.
That is correct. I do a thorough search of Mr. Paul Dupont, finding the knife that he talks about in a black tube containing 4 clandestine pills inside the grocery bag.
All right. Now, summing up this scene, can you explain to us in your own words what actions, and you don't have to be thorough to the extent that we go through this again, I don't want to do that. But just generally, briefly, what actions did you experience from the defendant that caused you to conclude that he was obstructing or resisting or hindering you as a lawful police officer in effectuating the arrest of Mr. Dupont?
As we can see in the video, he's in a look-like patrol car, which is a heightened state for me anyways. During my arrest, he is trying to distract me. He doesn't tell Paul that he can't put the bag in his car. He shines flashlights in my eyes. He's abrasive. He's throwing the Constitution, well, what he said was the Constitution onto the ground. He's trying to distract me. He's not listening to clear commands to leave the scene. After I had told him initially that I had no problem with him.
Now, we heard during previous discussions in here that there were mixed messages that you were giving the defendant. I heard 20, 30 times you told the defendant to leave, just leave, get out of here. You tell the defendant to do anything else?
There may have been other banter.
I understand there's banter. You're on the scene of a crime. You're trying to get control of the situation.
Yes, I told him to identify himself multiple times or to leave or be arrested. At some point after the drugs are discovered, I tell him that a crime has been committed and that the drugs came from his vehicle. He claims that he didn't know that they were in someone's possession, so it can't be linked to him. And he doesn't have to identify due to what crime has been committed.
Nothing further, Your Honor.
Mr. Jadal. You folks okay?
So, sorry,
Are we gonna replay or you don't know yet?
I don't know, I'm not sure.
All right.
But you've testified that prior to this altercation that everybody saw, you were following Mr. St. Clair's vehicle, correct?
I was surveilling the vehicle. Yes, correct.
Okay.
Prior to this body cam.
And so you were surveilling and you ran lean and you knew it was Mr. St. Clair in the vehicle, correct? Or you knew it was Mr. St. Clair's vehicle, I'm sorry.
I knew it was Mr. St. Clair's registered vehicle, yes.
Yes, okay. And at some point, when the video starts, there's somebody else, not Mr. St. Clair, approaching you, correct?
That's correct, sir.
And who was that person?
That's Mr. Paul Dupont.
Mr. Paul Dupont. So let's call him Paul. So Paul's approaching you, correct?
That's correct.
And at this time, Paul has a bag and he's approaching you, correct?
That's correct.
And then, as you say, a car begins to pull up, correct?
That is correct.
It was 150 feet away and it came closer, correct?
Approximately 150.
Now, at any time, was that car directed not to pull up closer?
No, it was not, sir.
Okay, so it was well within its right to pull up where it did pull up to, correct?
Yes,
Okay. Now, at that point, there's a bag in Paul's hand, correct?
that is correct.
And then this bag, as everyone saw, went into the car that my client was in, Mr. St. Clair, correct?
That's correct.
Now, at this point, you interact with Mr. St. Clair, correct?
I tell him that I have no problem with him.
Yes, you tell him you have no problem with him, correct?
That's correct.
Okay. And now you begin to walk closer to the vehicle while you have Paul in handcuffs. Is that correct?
That is correct.
And what you're doing is you're approaching the vehicle in order for you to get what you want, correct?
Partially, yes.
Now, you don't feel you need Mr. St. Clair's permission to reach in his vehicle, do you?
It always depends on the situation, the
Well-
incident.
Did you ask his permission or his consent to reach in his vehicle?
No, I did not.
However, you did reach in his vehicle.
I did.
Now, he was upset, correct?
He was.
And he explained to you that he was going to call your supervisor because one, you were stalking and harassing him, because as you've admitted, you were following him, correct?
That is correct.
And two, you reached in his vehicle.
I did.
And at that time, you flashed the flashlight in his eyes, correct? As you were going looking into the vehicle.
I illuminated the vehicle, which is standard procedure. Most of the time, if we review the video, my flashlight is on his waistband.
Now, at that point, once you have what you reached in the car for, you ask my client to leave, correct?
I do.
And he tells you he wants to call supervisor, correct?
That's correct.
And then now there's a conversation between you and him about who the supervisor is, and it's Friday night, correct?
Correct.
Okay. Now, you ask him to leave again, correct?
I've asked him at that point multiple times to leave or
And
be
then
arrested.
But he tells you it's within his rights to stay there, and he attempts to give you a constitution, correct? Or a pamphlet.
We would have to review the video again, whether or not I already told him if he was obstructing.
Okay. Now, as soon as this pamphlet that falls out of the car door, you tell him that he was littering, correct?
I do.
Yeah. And you tell him to get out the car and pick it up, don't you?
I do.
And then maybe 2 seconds after, you tell him to get out the car and pick it up and tell him to leave, don't you?
That's because I had picked up the pamphlet myself and shoved it back through the window, which was cracked about a ½ inch to an inch.
And then shortly after that, you tell him to leave and he tells you, I can't. Isn't that true?
At one point, he does say I can't.
And you direct an officer to go ahead and move so we can have a clear path, correct?
Correct.
And then you guys begin to talk again, correct? You and Mr. St. Clair.
He refuses to leave.
And you guys engage in a conversation, correct? You accuse him of perhaps transporting drugs, is that correct?
I'd say that's accurate.
Yeah. So you accuse them of a crime, and then maybe 30 seconds later, another officer comes, correct?
I'm misunderstanding your comment.
Between you telling him that perhaps he was transporting drugs, another car comes, your backup that you called, correct?
The second backup or the first
Yes,
time?
the second backup.
I don't know the timeline on it. We can watch it again, but 2 vehicles end up arriving.
So now his path to safely leave is obstructed, to say the least.
I would say it's obstructed, yes. However, there was other paths in which no damage to property would occur, which were paved or at least gravel that are traveled by vehicles.
Then at that time, the backup that you called are engaging and talking with Mr. St. Clair, correct?
Briefly.
Okay. So, and that's when the video stops, is that correct?
The video contains basically
As of
our
now,
whole
as of what-
interaction.
As of what the jury has seen, that would be a good summary of what the jury has seen and what has occurred to this time, correct?
I would say that's accurate.
Nothing further.
You were asked, Detective Belowski, that you did not tell the vehicle, I don't know how you talk to a vehicle, but anyway, that was the question. That the vehicle could not pull up. You said that's right. In other words, you didn't direct the vehicle not to pull up.
Correct. I did not
Alright.
get on the PA or do anything to not allow
I
the
understand.
vehicle to move
But you gave a series of directions otherwise, which we've been talking about for the last 15, 20 minutes, was to leave.
or be
So you
arrested.
might not have told the vehicle that it can't pull up, but you told the driver of the vehicle to leave many times.
That's accurate.
Now, is there any doubt in your mind that Mr. St. Clair didn't have opportunities to remove himself from this scene?
Mr. St. Clair interjected himself. I was there for multiple minutes while he was obstructing my investigation by myself.
When you
in
were
which
there
he
by
could move.
yourself, it was your vehicle pointed in this direction.
Correct.
His vehicle that he pulled up 150 feet pointed in this direction. Was anybody, any vehicle, any creature at all prohibiting his ability to leave?
Negative. My vehicle is parked more in what is like a parking area for the liquor wagon, adjacent to Sharon Court. So all of Sharon Court was free to leave while I was only there.
So the first time that we can create a scenario where maybe there was some obstruction to leave was when Johnson pulled up, Officer Johnson.
And I quickly order him to move his vehicle.
And did he move his vehicle?
Correct.
And then late in this review of the tape and the discussion that we've had comes Officer Herrick.
Correct.
So during that entire time up to Officer Herrick arriving, was there any obstruction of any significance at all to Mr. St. Clair leaving the scene at your direction?
No obstruction at that point.
Seemed to make an issue out of the fact that you were conducting surveillance. The question was stalking.
Correct.
Were you stalking?
I call it good police work.
I guess it did turn out to be that way, didn't it?
That's correct.
You suspected that possibly there was a connection between Paul DuPont and this vehicle based on what you had heard a few weeks before. And based on that, you processed it and you conducted surveillance and stayed with it to the point where you were able to determine that your suspicion was accurate.
Correct. And it's not a hunch. These were documented things such as Paul DuPont being a no drug addict because we've arrested him, or an incident with Mr. Sinclair and his lookalike patrol vehicle because there was a report and a shift brief. It was not just that I was drinking coffee and giving information. These were all correlations that I made from actual reports that are hard copies.
Was there any doubt in your mind that during this entire encounter that Mr. St. Clair, for some reason, didn't understand what you were telling him to do?
There's no doubt in my mind.
He's at a high level of agitation, isn't he?
I think that Mr. St. Clair wants to provoke police departments.
Nothing further. Thank you.
Recross.
Prosecutor just asked you, when this altercation first began, that my client was free to leave. And you said, yes, is that correct?
Yes.
Now, and isn't it true that when Mr. Paul, who was arrested, put the item in the car, you told him, I got no problem with you, but don't touch that bag?
That's correct.
My client isn't free to leave, is he?
That would be a matter of perception.
Don't touch that bag, but I got no problem with you. It's a matter for him to decide whether or not he's free to go or not. Is that correct?
I would say that I could say that at that point, touching the bag or staying on scene would be a brief detainment.
Now, and as we move along there, where you keep referring to the vehicle that my client was driving as the as the fake police car? Is that how you're at?
Look-alike police car.
Look like police car. Why is that important for you to bring out?
Because it's a matter of public trust.
Doesn't it also kind of piss you off that a citizen is in a look-alike police car?
Doesn't bother me in the least.
So we could start calling it a car now instead of a look-alike police car?
I call it a look-alike police car because that's my observations of the car based on Officer Johnson's report. Officer Johnson's report was that a female called because this look-alike police car, which she thought was Van Buren, honked a horn at her and she was forced to pull over.
So is it your testimony now that as an officer, you're not upset that a citizen has what you perceive to be a look-alike police car, not upsetting at all to you?
I would rather him not have it. That is clear.
Nothing further, thank you.
Lieutenant, you can step down.
Thank you, Your Honor.
What's next from the prosecution?
Is it an opportunity to have a moment, Your Honor?
You guys ready for a break? Yeah, let's take a break. Yes, let's take a break. Yeah, can we try to round them up? Get them in there? Thanks. No, okay, thanks.
Make them walk all the way around.
Watch your hand, man.
Such a beautiful room.
Yeah. You can have a seat anywhere you like, okay? Okay. You need, Sam in here?
Oh, yeah, I'll wait for him, yeah. Yeah.
Excellent, yeah.
Did you tell her to talk? I understand, huh? Don't need access to Texas.
On record or off record?
I'm gonna try.
On record or off record?
I want to talk about, we were before the court, we can put
On record or off record?
I don't know, I'm just gonna tell you what.
On record again, I think just
Go.
to be safe, you should put it on record.
There, go ahead.
So if the court recalls, we had a discussion, argued a motion back, I don't know, a couple, 3 months ago on other acts, other
404,
crimes
yeah.
that I wanted to introduce. And we agreed at that time that we would wait until the cross-examination of Mr. Belowski had completed.
Right.
And the court understands it's not character evidence as
Right.
such, but there's one tape that I believe that I can make a strong argument that should be allowed by the court. It's the,
Let me stop you, Rob.
yeah,
Is this incident the original incident between the defendant and Johnson that you referred to a number of times?
it is.
I just want to make sure it was the same thing.
It
Go ahead.
is. And that doesn't necessarily in and of itself make it admissible. But the
Right.
connection that I'm making is that The purpose for their investigation, some 3 weeks before this, leading to the debriefing to Detective Belowski, was the police vehicle and the problems that ensued. And what you see is you see a visceral reaction by the defendant in this case, where he takes massive offense to the fact that they're making this allegation, to the point where he even indicates in response to this that he's going to elevate this to a higher level because he knows the law, he knows his rights, and he effing hates the police. That's what he says in response to this vehicle issue that we're talking about.
Right.
So if that is an issue, and it was opened by Mr. Jadala during the cross, I believe that under those circumstances, it can be limited to motivation on the part of Mr. St. Clair's actions on the 6th, because it's consistent with his actions on 3 weeks before that. And we can address any concerns that Mr. Jadala would have with the jury instruction.
Response.
Your Honor, his actions are in trial, and actually my response to the motion actually goes to exactly what the prosecutor is saying. They want to introduce a past act showing that he acted in conformity with the character trait. It's character evidence. He's not here. He's not here because he's not here because he's belligerent. He's here because, Your Honor, he says that he didn't comply with an order of the police officer. And that's what we should be limiting to, and that's what the response to our motion is. Showing another act puts him basically on trial for another act that he's not charged with, that he has to answer to now. And that's not what the 404B statute is for. They are trying to put in a character trait to show you that he acted in conformity with, which is way more prejudicial than probative in this case.
Go ahead, Mr. Young. Go ahead.
If I was trying to put a character, I have 5 other matters that I probably would use before this one if I could get into character evidence. I'm tying it to the issue that Mr. Jadala raised as it relates to the vehicle itself. It was an area of contention. The vehicle itself, whether we're offended or whatever the case may be, or what brings attention to it. And what I'm saying is, it's not more than 3 weeks before that, this same matter arose as it relates to the vehicle, which shows that there's purpose, there's motivation on the part of St. Clair, because he reacted the same way 3 weeks ago that he reacted on January the 6th when it came to the vehicle. This is what I'm trying to say. There's a connection. And the connection is not his character. I don't care about his character. If they don't understand his character by now, there's nothing else that I can put on. What I'm trying to do is to close the loop on that one issue that I think was opened by Mr. Jadala during his cross.
And Your Honor, if I may respond.
Yeah.
It wasn't opened up by me in cross. I just simply asked the officer why he was characterizing the vehicle the way he was characterizing.
Right.
Not whether it was involved in other crimes or other scenes or other incidents. So that doesn't open up an avenue of evidence that he's trying to admit. It's very limited. My question was very limited as to why he was characterizing the vehicle that he was over and over again to the jury. Just to show the jury that obviously he has a problem with the vehicle. Not to open up any other evidence of prior acts or prior incidents. And that's what the statute is designed, and what my brief indicates why it's impermissible to allow that kind of evidence.
Mm-hmm. Yeah, so one of the things that, as the gatekeeper, one of the things I look at is whether or not the information being sought for admittance is likely to confuse the jury. I think it would. I also think it is more likely to be prejudicial than probative. If the jury had asked some questions, for example, about, the prior incident or how that was related to Mr. St. Clair or something like that, then maybe I'd have reason to think that that's a loop that has to be closed. But at this point, I don't think it is, and I'm going to deny the motion.
And I find, Your Honor, as it relates to this matter, again, this was brought up under 404B. If Mr. St. Clair chooses to testify, I have many things that's a different story.
I guess we'll argue about those then.
Okay.
We ready to bring him back in?
Yeah, I believe based on where we're at right now, we're going to rest with what we presented.
Okay. All right. Bring him in.
Stand up for the jury.
Exactly right.
He's had to rise from the juries where he's been defended.
I found one major design flaw, have a seat, in our new building, and I think I just found another flaw. If we had another foot between that wall and that first row of chairs, it'd make it a lot more usable, wouldn't it? Yeah. Yeah. I'm not gonna fix it though. All right, we're back on the record, and Mr. Young, I think you just told me that the people rest.
People rest, Your Honor.
Mr. Jadal?
Your Honor, at this time, the defense rests.
Oh, okay. Never should have brought you in then. All right, here's what we're gonna do then. I'm gonna kick you back out of the room. Probably take 20 to 30 minutes with these two gentlemen going over our final instructions, giving Heather a chance to update your tablets for final instructions, and then bring you back in, give you those final instructions, and send you back to delivery. I'm gonna guesstimate that between now and 12:30, like 12:30 is my target to have you in the room making final deliberations. So if I can hit that target or close to it, do you want to break for lunch or do you want to just keep working? Have you had any conversation? You might have it taken an open vote.
Keep going.
You okay with that? I mean, we don't have anybody that's got, low blood sugar or something, has to get a snack or. You're okay? Well, we can get you some food. I mean, if you need like a granola bar or something, with a building full of snacking coworkers, I can find you something to nibble on if you need something. So just let us know. So you're all right. We'll keep working and we'll do this. We'll get through this process as soon as possible. So if we can get you back to work before 12:30, we will. All right. So let's take them back out if you would. All right, gentlemen, if you would, let's go to final instructions. Yeah. Thank you. And Rob, you had submitted a proposed instruction. Do you have an extra copy of that for Samir?
You saw it, right?
Yeah, I have it, Judge.
Okay, we'll get to that in a minute.
I think you requested
Probably not.
two
Can you
other
pause it?
instructions. You want-
Yeah, and I don't think they're necessary anymore. I'll make sure.
Okay, leave meeting.
No, up the top.
Live stream.
Yep,
Yeah,
the live
yeah,
stream,
yeah.
quick